Good morning, Chief Justice, honorable members of the court. May it please the court, my name is Catherine Savoy, and I'm the attorney for the plaintiff appellant Regis College. I think it would be helpful if I began with a brief and general overview of events on this case. Beginning in 1927, the Sisters of St. Joseph founded Regis College in Weston and also purchased an adjacent parcel of 60 acres on the east side of Wellesley Street. The following year, in 1928, the town of Weston enacted for the first time a zoning bylaw. It's gone through numerous iterations and changes since then. In 1952, Weston incorporated an exemption for religious and educational uses following the state law, the Dover Amendment, which is at issue in this case. In 1975, the current version of the Dover Amendment came into being. Fast forward 30 years, between 1975 and 2005, in 2005, Regis submitted its proposal for Regis East, which is the project under consideration by the court today. It's a multi-generational, multi-use development to be situated in the adjacent 60 acres to the existing Regis campus. The Zoning Board of Appeals in 2005 refused to consider whether or not the project was entitled to Dover protection and denied the Regis's request for 3 variances. The 3 variances were having to do with 3 dimensional requirements applicable to educational and religious uses under the Weston zoning bylaw, and those were area, height, and setback. We just took an appeal from this decision to the land court, and that was also in 2005. And in 2009, the land court remanded the case back to the Zoning Board of Appeals with the specific direction that the zoning board make a ruling on the Dover applicability of the project. On remand, not surprisingly, the zoning board determined that the project was not entitled to Dover protection. And back up to the land court on an amended complaint in 2009, Regis moved for summary judgment on the Dover issue, and in January of 2010, nearly 2 years ago, the land court issued its decision that is under review today.
Now, if I could interrupt briefly.
Certainly.
Do you agree that if this were a senior housing facility where the only education provided were crafts, but yet it would have the benefit of providing substantial additional funds to help Regis through financial difficulties, that it would not satisfy the statute?
I think that I would say that it would not satisfy the statute in terms of educational purpose if all it had was crafts. However, the statute also permits nonprofit educational corporations to expand their facilities.
So you're saying that if they had, well, I'm trying to think what you mean, if they had decided to build an office building, nothing to do with just pure money raiser, that would be okay because its purpose is to furnish additional funds for educational purposes?
No, I think the use of the project must be for educational purposes, so that would not be okay. A shopping mall, an office building, something that is exclusively for the purpose of acquiring additional funds and has no educational uses associated with it whatsoever would not be considered a protected use under Dover.
But the educational use, I gather, has to be for its. I mean, it seems that the key issue is: are these elderly persons students?
That is the key issue in this case, and I think it is unquestionable that they are students.
Well, do you agree that the analysis should require a finding that the dominant purpose of the project is educational?
Well, I think we've argued that it should not require that as opposed to each individual building, structure, or component of the project, but certainly with regard to the project as a whole, to look at the dominant purpose or the primary purpose of the whole project is an appropriate view of this court. And I would submit that if you look at the dominant purpose of the project as a whole, what you will find is that education is the single unifying ingredient of all of the uses in the multi-use project.
But the fact it has all the features of assisted living, of an assisted living commercial project.
Well, it does have some of the features of an assisted living project. First of all, I think we have to distinguish our terms of assisted living as opposed to apartments for elderly senior scholars, which is how we have determined it. I think when you get closer to assisted living and critical care and nursing home, you're moving on a continuum.
Offer medical care, do you?
No, we do not.
So it's independent living, not
It's
assisted
independent
living.
living, that's correct.
So you, let me see, I guess I missed the subtlety of this. You say the dominant purpose test is okay so long as the whole project is looked at as opposed to the individual elements.
That's correct.
All right, so you wouldn't suggest a different standard where it's a nonprofit educational institution expanding. You wouldn't look at significant purpose,
I think you
more
should,
than incidental purpose or any other standard.
I think the court should always look at the significant purpose of the project as a whole. And I think when you look at the significant purpose, the dominant purpose, the primary purpose of the project as a whole, you cannot get away from the fact that this is an educational expansion of an educational facility on a college campus. It services 3 distinct populations of students.
So you say Judge Sands is just wrong as a factual matter?
Yes, I do.
Can I just go to those fact bases? And,
Yes.
as I understand it, he's determined based on the presentation of evidence that with respect to the elder scholars themselves, the senior scholars themselves, even though a portion of the agreement that's part of the record suggests that they must participate to a certain level, actually, if you continue, it's only that they must participate to the extent that they are able to, and if they're not able to, then you go to a further section that says if they're intentionally not doing it. So really, there's a rather small component of their entire existence at this. That's at least what I understand those findings to say. So setting that aside, and if that's a small component, looking to the other piece, which you're also focusing on, right? So that would be important to see what all these nursing students and all these other students might get from this, these buildings where there is no medical facility and there's no agreement that these residents participate with these students in any way so that they may fulfill whatever internship or other credit requirements they might have with the school. As I understand Judge Sands' problem with that is it was too vague. Is it too vague?
I don't believe that it is too vague. First of all, I will take exception to the fact that the senior scholars will only be, there's only a small commitment to education by the senior scholars. This program is going to be managed by the dean of the East Campus. There will be a wellness coordinator and an educational coordinator, a curriculum coordinator for each senior scholar that enters the program. When they enter the program, they will sign the residency agreement and they will make a commitment. They will spend a large sum of money to make a commitment to live on a college campus that is designed for elder people. We do not anticipate people coming to live in this community who are not also interested in having education be part of their life and being educated into the post-retirement years. I think
What's the duration of the time span for which an elder signs up for?
The elder signs, well, the duration that the elder signs up for is until, it can be as long as until they're no longer able, it could be until life, yes. And they may age out of the program, in which case they would have to go to the nursing home. They may die, or they may choose to live somewhere else. There's a number of reasons why they might leave. But while they're there, the point of it is that they get to participate in the marketplace of ideas of a college campus. It's a very unique opportunity for them, and I think it's a very exciting, very forward-thinking project. It recognizes these facts that we hear in the media all of the time, that by the year 2035, there are going to be 75 million people in America that will be older than 65 years of age. We also know that it is a proven fact that the more education Americans have, the more education they seek in their elder years.
Do
College
any of the-
campuses
I'm sorry, go ahead, finish your thought.
College campuses have to be dynamic, fluid, and changing in their facilities and their buildings. They have to come up with programs to accommodate this influx of learners that are coming onto their campuses, that have already begun to come onto the campuses. One of the amicus...
Well, do any of the elders have to take any of the courses that either undergraduates or graduate students take? They have to take
4 courses.
No, that's not my question. Do they have to take any of the courses that undergraduates or graduate students must also take?
No, they can take courses from the Learning Institute as well.
So that they could meet the educational component of occupancy by taking this other type of course?
Well, I don't know
nature walks.
No, nature walk is not.
You get credit for nature walks.
You do not get credit for nature walks under this program. It is very specifically excluded. The then president of Regis submitted an affidavit. She was on the curriculum committee, and she testified under oath that nature walks would not satisfy the requirement. But health and wellness programs and classes do satisfy the requirements, and undergraduates at Regis College take health and wellness programs, and so do most undergraduates at most schools in America.
Is what you, Regis, is offering, do you see a distinction between what it is offering and what was at issue in the LaSalle case?
I think there are many similarities. The distinction, I believe, with LaSalle is that it did offer the critical care component, and that it did, when people became not able to live independently. I believe LaSalle does have a small nursing home facility.
But educationally?
Educationally, I believe it's quite similar in terms of what the requirements are, and I've argued that in my brief, that in the then Chief Justice of the Land Court, Judge Kushan, described the LaSalle program as being most certainly educational in nature, and I would submit that that is true of the Regis program as well. Now, whether or not, I think the problem that at least I see from reading all the papers on this case is that the town of Weston and the interveners don't believe that Regis is going to use their property for educational purposes. They don't believe that they're going to enforce the educational requirement, and they're calling the whole educational component of the elder housing of the Elder Learning and Living Community Program window dressing. And I would submit to you that it is much more than window dressing. Regis's current president is Antoinette Hayes, has a background in nursing and health sciences and gerontology. Regis now has a gerontology certificate that requires 120 hours to get to the certificate of interaction and work with the elderly. Regis has always been emphasizing education across the life spectrum.
Would you say hypothetically that an elder could flunk out?
No, but that's an excellent question. No, elder cannot flunk out, and I would submit to Your Honor that talking about flunking out or passing or grading or getting a degree is talking about educational programs designed for a different population than the elderly. Some elders will want to get a degree. If you're over 55 or 60 or 65, you might still want another degree in your life, and you might want to go and live on Regis campus and enroll in an undergraduate or a graduate program, and then you would be subjected to the same standards that the undergraduate or graduate program would require, but you don't have to enroll in an undergraduate or graduate program. And the point is that traditional models of education cannot define an elder learning community. It cannot be sure. We have this tremendous opportunity for an intergenerational learning environment, this tremendous opportunity to be forward-thinking in our provision of learning opportunities for all of us who are going to be moving into our post-working retirement years.
Could an elder person apply to become admitted to Regis in the undergraduate program and live in a dormitory?
I'm sure if they wanted to, they could, if they got in.
Has that ever happened at Regis?
Well, I don't know if it has, because I don't know that particular answer, but I do know that in my brief I mentioned that we did have a Heritage Scholar program, and one 77-year-old woman graduated from Regis College, coming back and taking the courses and going through the program.
Quickly, could I ask you about money? So I understand that it's somewhere you pay $750,000 to $1 million.
That's correct.
And you say you get 90% back.
That's
but in the meantime, Regis benefits from any income, correct?
That's correct.
Okay. So there's the income component of whatever, 30, how much? 30,000 plus the 4,000 a year. That's
Month.
4,000 a month.
That's
Sorry.
correct.
So that's the amount that Regis gets, which is considerable.
It is.
And your argument is that this is just like football.
No, I don't think it's just like football,
Well,
but football's considerable too, in terms of
Yeah,
what
but
it
in
supplies
football,
to
only
the.
students play in, right?
Yeah. No, the point is to look at the financial model. It is called an endowment model. And what happens is that the residents pay the money in the beginning. They make the investment in the beginning. It is used, the money that is collected is used to pay off the construction debt. And then the income from that money is used to provide a financial reserve for the balance of for the balances that are required by the lenders. It's a model that has worked successfully in other projects.
None of it goes to fund the needs of the university, the college?
Well, it goes to fund the needs of the college, but don't forget that 90% of it is returned to you also.
So I'm really only talking about the income.
Okay. And the other important thing to remember, though, is that if you're looking at colleges, the price of college education, I mean, it seems outstanding. It seems kind of high when you first look at it, but when you really think about the price of college today, and that 90% of your investment in college is not returned to you, and you have most of the big schools today are charging, what, $55,000, $56,000 a year, plus graduate school, plus PhD. And this senior scholar program could go for a lot longer than what a typical 4-year, 6-year, 8-year, 9-year program would be. If a person moved in when they were 55 or 60, they could spend 20 years as a senior scholar. If that's what they chose to do, they'd have to be a senior scholar. They'd have to take the courses during that 20-year period of time. But it's not, and it's also just comparing apples and oranges to look at a 300 square, as Judge Sands did, to look at a 300 square foot dormitory room and to say that people who have worked their whole lives long and are now retiring should be happy with should be comfortable in a 300 square foot dormitory room, or should have to do a graded program, or should have to collect a degree. I mean, the whole purpose of education is broad and comprehensive. It's,
Ms. Savoy, your time is up.
oh, thank you so much.
Good morning, Mr. Chief Justice and Justices of the Court. My name is George Pucci, and I represent the town of Weston and the Weston Zoning Board of Appeals. Following up on my sister's argument about Judge Sands' examination of the facts in this case, I would like to start at the point where this is a case that's entirely appropriate for summary judgment. And as Judge Sands had pointed out in his opinion, it's not a question over a dispute over material facts, but the legal meaning of an accepted set of material facts.
So we should take all of the representations that Regis has made, all of the affidavits with respect to purpose and how this will unfold as true.
Correct, Your Honor, except to the point where there are legal conclusions. In other words, it's ultimately for the court to decide whether or not this is a protected educational purpose under the Dover Amendment.
Gotcha.
If there's, and there are voluminous pages about
So when the president has an
conclusory
affidavit describing how the
that
program
is
will work,
educational.
we take that. No, we
How the program works, absolutely, Your Honor. And Justice Sands' summary judgment decision did not disbelieve any facts set out by Regis. He just disagreed with the ultimate legal conclusion. I was a little less, polite than Judge Sands. I call it a question of confusing between quantity versus quality. And what we submit in our papers is that Regis confuses the fact that they are putting a voluminous quantity of materials before the court to support the alleged educational purpose, that overcomes the qualitative evidence.
Well, let me ask you the same question I asked Ms. Savoy. Do you agree that if these elderly residents are students, you lose?
Well, it would depend on, again, fact-specific, Your Honor, about how you would define a student.
Well, that's going to be my next question. But the first question is, if they are students, do you agree you lose? No matter how plush or how much money it may generate for the university, or for the college, if they are students, it doesn't matter whether these are $1 billion condominiums or 300-foot dorms.
Yes, Your Honor. The luxuriousness of the accommodations is only one component when looking at the purpose of the project as a whole. And I don't mean to beat a dead horse on this issue, but you really do have to focus in fact-specific about the meaning of what a student would be.
Okay, and so that's my question then. How should we define a student?
Well, here, Your Honor, Regis hasn't adequately defined the alleged scholars or students that are going to be at Regis East. What I point out on that issue, and again, very fact-specific and no nothing disputed on this, there will be no examinations, grades, or formal requirements of any kind required of these students. The courses may be audited, taken over the internet, or taken as independent studies. The academic requirements will be, quote, adjusted, close quote, to meet changing needs of residents resulting from physical or cognitive decline.
Is the only way to learn, though, in a degree program, is the only way to learn to be graded on what it is you have learned? I mean, are you using an educational model that is essentially the traditional model of, educating young people for careers of one sort or another?
Right. No, Your Honor. We would agree that educational purposes as defined under the Act would include non-traditional educational purposes.
So all the factors, though, that you're discussing as not being adequate to define a student are all related to the traditional model, however.
No, actually, again, it's looking at the purpose of the project as a whole and seeing if really the true purpose is primarily and a dominant purpose of educational purposes.
No, so is that going to be defined by the population of people there? Or, I mean, I'm very interested in how this correlates with other kinds of building projects that an educational institution could want, like, for the football stadium, the alumni center, social center, performance arts center, and athletic fields, things like this, which, you could argue served an attenuated educational purpose, but they were not directly learning related. And yet, if you look just at the facility itself, you could argue, well, that's not something a college should be able to build because it doesn't have a dominant educational purpose.
You do have to look at the proposed use of the land or structure. We agree with that. And if you take traditional campus buildings, say in Massachusetts under a Dover Amendment analysis, say Boston College wanted to add a tier to their football stadium, then I would suggest that the proper analysis in that case, assuming it didn't comply with zoning, I don't know what the zoning is in that case, but there would be a Dover Amendment analysis to that. Is this use a protected educational use? BC would probably be able to make a compelling case that within BC's defined program, what they have, that the football program is an integral part of the BC campus.
The school gets to define what's educational. Well, then why hasn't Regis defined it then? Why shouldn't that be respected?
The school gets to try to make a case about what defines it, and Boston College may be able to make a more compelling case for the educational use of an extra tier on their football stadium or Notre Dame than Regis might be able to do that.
But does that mean that a college can never change or expand its educational mission?
They can, yes, they can expand the mission if that mission is properly defined. And again, they have to present facts which show that the predominant or primary purpose of the project serves educational purposes as defined under the Dover Amendment.
But you're not suggesting that grades and exams are necessary. There are lots of alumni educational programs run by universities that people come in for 2 weeks, they stay on campus, maybe at some very nice upgraded facilities, they take a particular course with a particular focus, they don't take an exam. That wouldn't be educational?
Correct, Your Honor. Grades in themselves are not necessarily dispositive on the issue, and that's what the appellees contend to the court.
Well, grades and exams are not dispositive.
They're not dispositive.
Degree is not dispositive by any means.
Your Honor, they're not dispositive, but they're relevant. So what the court did here was he carefully examined all of the evidence before him that was submitted by Regis, and he went through component by component. What he did not do is what the judge improperly did in the Martin case, the Mormon steeple case. What happened there was the overall use of the temple itself was deemed a religious use. Then what the judge improperly did there was he applied an independent use analysis to the height of the steeple. What the judge had to do there was apply an as-applied analysis, what reasonable regulations could be applied to the height of the steeple, which actually did happen.
What's the difference between, in your view, between LaSalle and this?
Actually,
You have some argument about the facts were different than the tax case, but...
The original LaSalle and this project are very different projects, and Judge Sands pointed that out. They had less than 50% of the building space involved in the project was devoted to living quarters. Here, of the 766,000 square feet of project, including 11 stories, 2/3 of the space is devoted to strictly residential facilities. That's a big one in the original LaSalle ruling. The other thing that happened in the LaSalle case was that use determination was based on an agreement for judgment which the city and the project proponent had entered into. So it had less than the 50% devoted to residential quarters, and then it did have very stringent requirements with regard to the program.
High school diploma, right?
Yes, Your Honor. It had a high school diploma. It also had clearly defined course requirements, 450 hours of courses per year. And what I would point out with regard to the LaSalle case, which is crucial here, ultimately, when LaSalle Village was denied favorable tax treatment, then that case went to the appeals court. Now, yes, it was examined under the tax statute as opposed to the Dover Amendment. However, there was a primary purpose analysis applied to LaSalle Village as it is currently operating. And what I'd point out to the court is currently, with regard to LaSalle, it's exactly analogous to what Regis is proposing here.
But the fact that this could be taxed doesn't mean it's not educational for the Dover Amendment, does it?
No, Your Honor, but the only thing I would point out about that is the evolution of what happened in LaSalle. What was actually being proposed and how it actually ended up being operated has been ruled now by the appeals court to not constitute a primary educational purpose.
For purposes of the tax statute.
For purposes of the tax statute, correct, but it's still a primary and dominant purpose test which gets applied here. So originally, the LaSalle program was much more clearly defined than what's going on with Regis. And again, if you go to the purpose of the project as a whole, and again, not examining a use analysis with regard to each particular component of the project, but applying it, considering each relevant component of the project, and then looking at how those relate together to determine the primary or dominant purpose of the project as a whole. And I'll go back. In addition to these basically non-requirements with regard to people coming in, and again, they don't have to. Their requirements can be adjusted depending on their physical or cognitive decline.
Why is that a problem? I mean, schools all the time accommodate students with various difficulties, and if it happened to be dementia, I would think that an elderly student at a school would be given accommodation for that.
They don't have to take them at all at that point. And I would point out as well, the average age of the resident entering into this facility is 75 years of age. So if it gets adjusted, that means they don't have to take the requirement at all.
How do we know the average age? I'm sorry, we don't have a facility here.
It's in the materials. Before the court, that Regis expected
expected
that the average entrance age would be 75 years old.
And that's relevant why?
Just in terms of, it's only relevant in terms of looking, as a practical matter of the residents that are coming in and, obvious physical or mental decline that could occur in the later years.
And those people can't be educated?
Oh, no, they can, Your Honor, right through the, as long as it takes. And we're not disputing that there are educational opportunities for people in their 70s, 80s, or 90s. There are. What we are disputing is that the predominant purpose of this project is educational. And then I would take those issues about and there are no real eviction procedures spelled out if they don't comply. And I would just point out in closing, I say that my time is up, comparing all of this to the overwhelming financial purpose of the project. The original conception of it was to deal with the fact that Regis had been operating in the red for many years, $700,000 to $1 million entrance fee, $4,000 per month.
So what if it does that? So what if it does that? I mean, why is
Because
that
we're
so
looking
bad?
looking at, it's not necessarily bad, it's a matter of what is the predominant or dominant purpose of the project as a whole is overwhelmingly financial, and a project that has financial purposes, it may not be a bad thing, it's just a matter that it doesn't comply with zoning, it's not entitled to
But
Dover Amendment
universities and
protection.
colleges add master's programs that cost a lot of money totally for financial reasons, totally. That would still be educational.
Yes, Your Honor, but here again, on the litany of voluminous facts that are before the court, it shows that the overwhelming purpose of this project was strictly for financial purposes to get Regis operating back on the black.
But what if the sole purpose, let's assume Regis wanted to build a Saudi studies program to bring in the sons of Saudi sheiks. Sole purpose was to make money. Would it not be within Dover? Because its sole purpose is to make money, to bring in students from Saudi Arabia who will pay a fortune?
If the sole purpose of the project was financial and not educational, yes, it would not qualify for Dover Amendment.
Even though they had to matriculate and be students and everything?
If couched in those terms, sole purpose, you would have to say that it's not for educational purposes under the Dover Amendment.
All right, thank you, sir.
Thank you, Your Honor.
Good morning, Chief Justice Ireland and members of the court. I represent the interveners, which include some direct abutters who live in the woods in Weston and will be facing an 11-story tower if this project were permitted to be built. I'd like to address Justice Gantz's question. I do not agree that we lose if you conclude that these senior residents are students. I would suggest that we would lose only if the activities and the uses that those seniors make of this residential project is primarily that of being a student. Now, I'm a student of the decisions of this court. I read them at home. That does not mean that my residence is exempt from the zoning requirements applicable to residential structures. And the reason is that there's a balancing that has to go on. And that balancing, this court has recognized in the Tufts case, is reflected in the Dover Amendment.
So you're saying that if they were to build a new dormitory, no educational purpose except to provide a better and more appropriate dorm, that it would not be within Dover?
If you look at the college cases, Your Honor, you'll find that for the most part, what the colleges are coming to the courts with is a project on a core existing campus where there's no question of whether it's part of the educational use of that land. And the question is, as applied, are the regulations reasonable? I would suggest to you that if a college or university is going to go off its existing campus set up for an existing program and go far away and purchase new land and buy a housing project and nothing is going to go on there but housing.
Of students?
Well, if the students are a typical traditional undergraduate, it would be easy for the college to establish that they are primarily using their residence for studying and educational purposes as part of the program. What I would suggest to you is that while there's nothing wrong with non-traditional programs, and of course the social science of education keeps evolving, and we're now focused more on education in the senior years and education that isn't necessarily part of a degree program. But the less traditional it gets, I think you'll see all the way back to the Cummington Art School case, the higher the burden of proof that the educational institution faces to show that it is a primarily and dominant an educational use. And here we have something that the trial court concluded, based on the undisputed facts, was not primarily and dominantly an educational use, that there were certainly elements of education, all the wonderful things that Regis describes in its literature and its program. And again, this case is not a referendum on the merits of a project. The case is about whether the project is sufficiently educational so that it should be exempt from zoning. So to answer your question, it's not just, are they a student? It's to what extent are they a student on this particular parcel of land. I'd also like to note that we have to think about the functionality of the Dover Amendment test. This is all about land use, and we have to have a rule that is going to equip building inspectors and zoning boards to be able to make a judgment when a particular project comes before them as to whether it should or should not be exempt. They're not experts. However,
Say something is primary or dominant, I mean,
what I would
why
suggest to you...
Why is that useful to, I mean...
It's necessary, Your Honor, for this reason. The world of land use is all about making distinctions. We have different rules.
But I'm just saying, I hear you, but I don't know, it seems to me everything is going to be fact-specific. Everything is going to be fact-specific. You can label it, well, this is primary or dominant, or this one isn't, but I guess I just don't understand why that's a useful way to think about this.
Why primary and dominant is useful?
No, the concern should be how building inspectors are going to implement this.
Well, Your Honor, I think that the Dover Amendment was meant to allow colleges and universities to go forward and develop property for educational uses and to allow towns and cities to apply their zoning rules where appropriate. Someone's got to make the judgment, and a common sense test of the primary and dominant use, I think, is the only test that makes sense.
No,
I would like to address the LaSalle case that
No,
I'm out
you
of
know
time.
you're-
Thank you, Your Honor.
I'll let you finish up if you'd like, but make it brief, please.
I would suggest to you simply with respect to LaSalle that although it's a tax case, this court made clear in the Fitchburg case that tax cases are appropriate to look at in making Dover Amendment test analysis. The Fitchburg case looked at the Cummington Art School case, which was a tax case, and I would suggest to you that with that in mind, I commend to you the appeals court decision in LaSalle.
Thank you. We'll take a brief recess.